Guys, I think we have about half the people here who signed up, so these days that's probably a quorum. Thank you all so much for being here. I'm Anne Marie. I'm with the Charlottesville Regional Chamber of Commerce, and we are so excited to be partnering with Cville SHRM this fall to present some crucial HR information for you guys. We have a lot of people in the house who are not yet chamber members, a few who are, so if anyone is interested in membership or want to know more about the chamber, please talk to me after. I'd love to tell you more about it. And with that, Sharon, would you like us to start with some introductions, or shall we just get into the meat?
No, I think if everybody wants to introduce themselves and the company they're with, that'll help us maybe also drive some of the content.
Okay, very cool. And I am video recording the presentation today so that we can share that afterward. Is everyone comfortable with that happening?
No. Stay right here.
I'm ready.
Don't want to get to that.
No. You can move right here.
All right, so let's see. Let's start with introduction. We're going to go all the way to the far corner. Veronica, will you start us off?
Hey, good morning. Good afternoon, everyone. My name is Veronica Dumas. I'm the Director of Sales at the newly opened Comfort Inn and Suites Charlottesville. We're located right near the Hollymead Town Center.
Hello, I'm Anna Payne. I'm the Director of Sales at the Dairy Market in the Brick Cellar, which is right up the street from you guys.
Anna, we need to talk to you for
Right,
a second
exactly.
before you
Yes,
leave.
I'm Kathy Kilday. I'm with the IV Group, marketing agency here in Charlottesville.
I'm Melanie Miller. I'm Director of People Operations with Yay Lunch, which is a startup that started in Charlottesville.
My name's Laurie Miller with Design Electric Incorporated, Carlton Avenue. I'm the payroll and benefits manager.
My name is Caitlin Morris. I'm with Launch Consulting, and we are a woman-owned engineering consulting firm.
I'm Cliff Barkins with Monticello Airman Business Operations Manager.
I'm Bianca Washington, Administrator and co-partner of Sister Sue Care, an in-home health care agency.
Welcome to Charlottesville. I'm Marianne Hardy. I'm the HR Director for the city. And thought, since we just finished our draft, I just wanted to get a chance to Sharon to introduce myself and welcome you all here and just have a chance to meet some people.
Great. Welcome. Okay. So I'm Sharon Burleson. I'm the president of the Charlottesville SHRM chapter. So also, if you're not a member of Charlottesville SHRM, we'd love to have you join us. I'm happy to have you join a meeting without becoming a member first, so just let me know. We are alternating meetings between each month between virtual and in person. We want it to be convenient as well. But we do love the networking. We just finished our annual conference, which we have each year in September. And I think that we were back in person for the first time since 2019, right? So anyhow, lots of opportunities to network and get some good content information, programming information each month. So we're happy to be partnering also with the Chamber. One of our goals as a chapter is to be a resource for businesses in the community. And HR professionals are those who don't have HR in their title, but absolutely have HR duties. So with that, I'll let you introduce yourself before we get started.
Okay. So I'm Laura Fekishazy. I'm Vice President-elect for SHRM. And so we thought that this kind of discussion would be a good team effort here because we both come kind of different perspectives and different group sizes and how these kind of employment laws will apply to various aspects. Oh, okay. Well, guess it. You sit and you get to introduce yourself.
Yeah. Tia, would you like to introduce yourself?
Sure. My name is Latia Warner. I'm the HR director. I was trained by Sharon Burleson.
Okay. Okay, we'll forgive you.
Thank you. She knows me.
Okay.
Oh, I'm happy to be here.
Welcome.
Yeah. So last month we talked about recruiting, and we were talking about how to be creative. And so, do you mind if I share?
No.
So my kids attended private school in the area, and every morning, almost every morning, because they had to be there earlier than other students, because I worked there, we went to a small coffee shop, and Latia greeted us every morning, knew my name, knew my kids' names, checked in on them daily, and I said, I can't train that. and I want her to work for me. And so I brought her over to the school, and here she is, moving on. She
That's
left me at the
your
school,
own
but that was okay too.
That's okay. Years later.
Years later. Anyhow.
Thank you. Thank you, Sharon.
All right, so we will get started. So I'll start by saying, clearly not employment attorney, an attorney of any sort. And so a lot of what we say in HR is, I don't know, let me check into that, or we'll get back to you. Because we
Or
ourselves, yeah, maybe we can do that. We ourselves have to contact our employment attorney. We have to reach out to resources like SHRM, National SHRM, because we can't retain all of the information that we need to answer questions immediately all the time. So we're going to go through some of the labor laws. I know this was catered to somewhat of small businesses. So this is a document from National SHRM about federal labor laws by number of employees. And so you read through this list. All of these on this page are for all employer sizes. So we're only going to kind of talk about the ones that start where there's different numbers of employees that you're required to comply with. So for OSHA recording, we'll talk about OSHA, ADA, GINA, Pregnancy Discrimination Act, Title VII, Age Discrimination and Employment Act, COBRA, EEO1 reporting, FMLA, PPACA, and the Worker Adjustment and Retraining Notification Act. So for OSHA record keeping, there are 2 exemptions to OSHA record keeping requirements. The first exemption is for companies with 10 or fewer employees. And then there's these companies must keep injury and illness records for only if OSHA specifically requires them to do so. And then the second exemption is for establishments classified that are certain low risk or low hazard industries. So typically real estate, finance, retail, insurance, in the construction industry, so we have to comply with OSHA. Stop us if you have any questions. We will have some handouts. I didn't make copies for everybody trying to save paper, but we will be happy to email them out to the group today. Americans with Disabilities Act, or ADA. So this became law in 1990. The ADA is a civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life, including jobs, schools, transportation, and all public and private places that are open to the general public. So the purpose is to make sure that people with disabilities have the same rights and opportunities as everyone else. Any questions about the ADA? Okay, so GINA, the Genetic Information Non-Discrimination Act. So the EEOC enforces the Genetic Information Non-Discrimination Act of 2008. So that prohibits the use of genetic information in making employment decisions in any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits, or any other term or condition of employment. And so what is genetic information? It can include family medical history, information about an individual or family member's genetic test, such as tests to detect whether an individual has an increased risk of developing certain cancers or other diseases, and the fact that an individual or the individual's family member has sought or received genetic counseling or participated in the trials. So you can imagine that, health insurance, for one, is very expensive for companies. And so, you could use that information if somebody does have a medical condition and you don't want to cover them on your health insurance plan and have your claims increase, so you could deny them employment if you have that information. And so clearly not lawful and shouldn't be doing it. And so you should never use that information to make a decision. It's unlawful for employers to request, require, or purchase an applicant's or employee's genetic information. So that means the employers must tell their healthcare providers that they cannot ask about family medical history when conducting post-offer or fitness for duty examinations. So I don't know if any of you do fitness for duty.
Oh, yes.
So we do a wellness program, and also we do an unofficial wellness program, but we offer discounts if we have our employees get a physical. We want to get them started with making connections with a family care physician to kind of monitor and maintain their health. And we say, do not give us any results. We only want you to have this affidavit signed that has your name and the licensed medical provider signs that you had this exam, and we don't want any of the results. No, we don't mind giving it to you. We don't want it. We don't want it. We don't want it. Title VII of the Civil Rights Act of 1964 was amended in '78 to include the Pregnancy Discrimination Act. So do not discriminate against anyone that is not only not pregnant, but asking the question, are you thinking about starting a family?
Right.
And believe it or not, I had that question asked to me many years ago in a job interview. At the time I didn't have kids, and they wanted to know about when I thought I would want to have kids and start a family. I was like, thank you very much. We can stop the interview now. And then Title VII, the Civil Rights Act of 1964, as amended, prohibits discrimination in employment based on race, color, national origin, sex, including sexual orientation, gender identity or expression, and religion. And then the Age Discrimination in Employment Act of 67, the ADEA, which prohibits any discrimination against persons age 40 and older.
So pretty much everybody falls into this. Somebody falls in that category in a variety of things, because it doesn't identify what race is. So just bear that in mind. It's not just particular groups of people. It does apply to everyone.
Right. Can they do the job?
Bottom line.
Bottom line, can they do the job? So COBRA, and again, we'll send out the sheet that has how many employees you need to have in order for you to comply with these or not. So COBRA provides temporary continuation of group health coverage that would otherwise be lost due to certain life events. What does it do? It requires group health plans to offer continuation coverage to covered employees, spouses, dependents, that would be lost due to certain events. And so I learned early on in my HR career, we had an employee that left, covered the spouse and son. The COBRA notice was sent to the employee and did not say and dependents. So the employee did not want to continue coverage, but the son did. The son didn't get a notice. And so instead, a lot of folks that will cover their dependents don't give you for an adult child who may be at college or live outside the house. They don't give you their separate address. And so, after talking to attorneys and then, our brokers, we just find that we send it out and we change the labels to and any dependents. So that's something that I learned early on.
And so bear in mind too, state law does it a little differently than federal law. So you want to make sure there's less amount of employees you have to retain for COBRA, for state law versus federal. So some of these might also bear in mind what we have information is on the federal, but you might want to double check, especially COBRA, how Virginia state, and I think Virginia state is 2 or more. So
it's everyone.
So that's pretty much everyone if you offer health.
So if you wanna, you could. I didn't know you had that printed out. Yeah. You could look. You wanna give them the numbers of employees needed once we get to them.
Yep. Okay. Let's see. So really the cutting off point is when you start to have over 50 is when new laws start to apply to you. So far what we've talked about
OSHA, I think is 10.
It's OSHA's 10.
Yep, starts right
Oh, there, sorry. Okay, I flipped the wrong side. Yeah. So, yeah, OSHA, you need 11 or more. The ADA is 11 or more, or 15 or more, excuse me. GINA is 15 or more. The Pregnancy Discrimination Act, and remember, Virginia State back last year implemented a separate pregnancy, and you must be giving them a copy of the act upon hire to tell them the difference. And for pregnancy, that starts at 15 or more, and Title VII starts at 15 or more, and then ADA starts at 20 or more.
So we have, we use brokers. We have about 500 employees, but they will help us with the employee notice document that we get out in every new hire packet. And so it's okay to have them all together as well, where you're not giving out single acts or documents. So I think the next one is the EEO-1 reporting, and that's required
100 or more?
with 100 or more.
Mine stopped. So I didn't get
So how many in here have to file the EEO-1 reports?
What's the time frame that they have to?
So July 1 is usually the due date of every year, for
Okay.
it to be filed for the previous calendar year.
Okay.
And they, during COVID, they moved the dates a little bit to accommodate what was happening, but I believe this year went back to July 1.
And so what you see on the screen, there's the EEO poster.
And that needs to be posted in a prevalent place where all applicants can see, but as well as all your employees can refer back to it as well. And so I work in an organization that has 2 or 3 sites, so it needs to be at each of those sites.
If you're doing virtual interviews, how are, if you, so they have to be visible for
So if
an
you put it
applicant?
like on your website, is one suggestion. I know because that's just a new trend with COVID, is doing those virtual. And you just have to have it relatively available to them to be able to see.
Okay, so employers who have at least 100 employees and federal contractors who have at least 50 are required to submit the EEO-1 report. So that's something else to consider other than your state laws. Are you a federal contractor? So there's other reasons why you may have to comply differently based on your number of employees. So the Family and Medical Leave Act, so FMLA, this entitles eligible employees of covered employers to take unpaid job protected leave for specified family and medical reasons. You can also take it for military deployment. There's also separate rules in place for school systems, so that it changes a little bit if you were an employee in a school. So the Department of Labor, EEOC, I'll have the websites up at the end, but if you are a smaller business and you're an HR department of one, or you're in a position where you handle the HR tasks, those are some really good websites to have bookmarked. So for FMLA, if someone needs, they usually have to work for you for a year, and there's also an total hours amount. They are eligible for up to 12 weeks initially of protected leave. You have to cover their benefits during this time. It does not mean it's paid leave, it's just protected. So you have to hold their job. When they return in 12 weeks, you have to offer them a similar job and a similar role with similar pay. So you want to make sure, and there's also notices that have timelines that you have to send out. So there's the initial notice that you're either eligible or you're not, and then there's a follow-up notice that goes in more detail that says this is what's going to happen with your benefits. They will continue, but now that if they don't have any paid leave to supplement them during the 12 weeks, then we have to figure out how do you get those deductions, how do you get the employee cost of their benefits. So that document or that worksheet goes through. You're gonna give us a check every week, or we'll figure it out when you get back, and then we'll take it out over the next 2 weeks or 2 months. You know, however you wanna work that out to the advantage of your employee.
Question, Sharon. So, you know, in certain positions, people hold, isn't there something that it
The
says?
key employees.
Yes.
Yes.
Tell me a little bit about that. Can't you, do you have to hold it for 12 weeks?
Do
If
you have
they
to
are
hold their job?
key
No, if they are a
employee.
key employee, and that's, let's see if it's on the, fact sheet. Yeah, summaries.
That's two, before you designate or undesignate, I would recommend you talking to an attorney, cause key employees is really, you know, it might be key and essential for your organization, but you're gonna have to back it up with the why.
Right.
And it's not an easy determination, and so again, this would be, we're not attorneys, and so something like that, you really need to walk through. Cause if you're not, in a sense, you're gonna deny them their family leave to some degree, if you designate them a key employee.
Right.
And so you,
And typically they are your
like your executive
your
level,
executive level, which
founders
makes
or
it
that.
even more,
Hard to say no.
Them the top 10% of your wage earners.
Right,
In order to be
exactly.
able to designate them, so that's a sticky one.
It is.
Definitely talk to legal.
yeah, have them help you navigate that, for
Right.
sure.
Good
If I get
question,
a,
though.
yes, great question. If I get any sense of, I'm not exactly sure, I'll reach out. It is well worth the hour consultation or the conversation you have with them. And they are also very aware of any outside of kind of compliance with laws, just general employment disagreements, right? They're gonna go back and look at case law, and they're gonna have access to all of that. How do they think a judge or a jury would rule in it, or what has happened in the past? And typically they will drive you based on what has happened with recent case law. So PPACA, the Patient Protection and Affordable Care Act. It actually has two parts, the PPACA and then the Healthcare and Education Reconciliation Act. So the act is 974 pages.
Light reading.
Light reading. Which is why I find organizations like SHRM or your attorney very helpful, because they're very good about summarizing what you need to know and bullet pointing the things that you need to follow. Does anybody have any questions about PPACA, the ACA reporting?
Can you leave that slide up for just a moment?
Do you want me to read it? Okay. So it's the Affordable Care Act, ACA. So it was enacted in March of 2010, and the three primary goals were to make affordable health insurance available to more people. The law provides consumers with subsidies or the premium tax credits that lower costs for households with incomes between 100% and 400% of the federal poverty level. I'm expanding the Medicaid program to cover all adults with income below 138% of the federal poverty level. And not all states have expanded their Medicaid programs. So again, always think about federal, state laws, and also if you're a federal contractor, anything else that may impact how you manage your workforce. And to support innovative medical care delivery methods designed to lower the cost of health care generally. So I put a link at the bottom. There is a really, I think it's like 5 minutes, but there's a video that kind of takes the ACA Act and puts it into a cute 5-minute video that is also very, very helpful, I think, to watch.
So hopefully too, your payroll administrator or your payroll can help you navigate that as well, because many payroll companies will offer that benefit to do the ACA and the reporting for that. So double check if you're currently doing it. I know I worked for an organization in the past where I physically had to do all that, and it's a challenge. And it was 700 plus employees, so I encourage you to check to see if your payroll company will do it. Then you just have to review.
So the Worker Adjustment and Retraining Notification Act of 1989, or WARN, the WARN Act really is, it talks about if you are laying off and how many employees you can lay off without needing to provide these notices. So it provides that with certain exceptions, employers of 100 or more workers must give at least 60 days advance notice of a plant closing or mass layoff to their affected workers or their representatives, to any state dislocated worker unit, and to the appropriate local government. So I don't know, I thought about this when we, February or March of 2020, like, well, were we gonna still be able to work? Were we gonna be considered essential? Were we gonna have to lay off a chunk of employees, and then this would come into play? And so, first thing I did was make a call to the attorney. So, retire path. So this is something that Laura, and this is how
right.
HR works, right? We're
Exactly.
sitting at the conference.
I get a text, oh, we need to look into, because my boss got a little email that said, oh, Virginia's gonna require us to do retirement. Look into it. I'm like, oh, that's new to me. And so, and having to have Sharon represent, I'm like, look, what is this about?
I don't know.
Google.
And so there is, Virginia has put in place, it's gonna be required in 2023.
Right, July 2023. But you have to have a retirement program in place. And they do offer one that is a Roth option, for minimal cost, no administration, no FICA responsibilities. So for small organizations who don't wanna take on that liability, they do offer options that you can enroll in. And I'm still kind of investigating that myself.
Right. So it was created by Virginia state law to expand access to retirement savings and provide more Virginians with a path to economic security. And so retirepathva.com. You probably want to look into that. I think when we read it, it was, they were gonna start contacting employers in was it November or January?
I think so.
So if your business is affected, you're likely to get something in the mail sometime soon. But ahead of that, this would probably be a really good website just to check out.
What size company is that for?
I don't think it's for all, but I think it's like 2 or 3. I mean, it's a
It's
small
very,
amount.
very small.
So.
Very, very small.
And if you already have a retirement program,
Then you don't have to worry.
you don't have to worry.
Cause you follow.
No matter what the rules are.
Correct, right.
Okay.
Cause you have one in place.
So we'll move to handbook policies if we're all good on the, if you wanna read some of these. So when I put the PowerPoint together, these are suggested policies to have in your handbooks. We're certainly not gonna go into all of them, but if there's one that piques your interest and you have a question, feel free to stop and ask.
So, handbooks are really a good source, mainly because you get an opportunity to present all your policies in one document. But bear in mind, your handbook is a working document, and so there are times when policies are going to need to change. So think that through as you're developing your handbook. So things that we and SHRM recommend is certainly is Virginia's employment at will state. So you wanna state that up front. You also wanna state that the handbook is not a contract, that it is, subject to be changed, and that this is our guidance and direction on things. So you wanna talk about your equal opportunity, and your commitment to diversity. You wanna include the ADA if that applies to you, and the reasonable accommodation, and you might wanna talk on who do they contact and kind of the structure of that. You also wanna talk about your harassment and your complaint procedures, and who do they go and talk to, and kind of examples of what might be considered harassment, but remind everybody that harassment is really making you uncomfortable in the workplace. So my interpretation of it might be different than your interpretation of that, and so you want to just say these are some examples of that. You want to talk about your conflict of interest and confidentiality. I work for an e-commerce business, and if one of my designers decides to, hey, I want to work on the side for another e-commerce business that does attire, I have a problem with that. That's a conflict of interest. So you want to state that up front, of what that expectation is. And you want to talk about confidential information. And so remember wages, even though it's not considered confidential information, you know, for us to share, if that person wants to share their own information, they can and shouldn't be disciplined for that. Also with confidential information, it kind of falls into, what is the National Labor, even though we don't, right, a relations board. Even though we don't have unions per se, a lot of what they put into place applies to us as employers. And confidential information is one of those aspects, is protected. And so that an employee can whoop and holler about what they're doing and be protected. And so that's scary.
It is. So speech about, if you have a group of employees that are not in supervision, but they are complaining about pay, benefits, environment, it is absolutely legal for them to do that. And if you tell them, you know, you need to quit saying you don't make enough money or benefits or poor, or we'll discipline or terminate you, well, they are protected by the National Labor Relations Board regardless of whether you're in a union situation or not. And that's a time when you take that opportunity to maybe survey your employees, because if that small group is feeling that way, your whole workforce may be feeling that way, and maybe you do need to look at benchmarking pay and compensation. But it is protected.
So you also want employment relations, you know, about privacy, how you're going to protect their social security numbers. Because unfortunately we still do need that information for payroll and that type of thing. And so we do need to collect it and how you store it. Employment classification, it's really important to identify to the employees, are you full, are you part-time, are you seasonal, so they know what applies to them, and this handbook can kind of lay out in generic terms what those mean. Your work week and your hours of work. Not everybody has a Monday through Friday or a Sunday to Saturday work environment. I worked in hospitality, and we, to help with overtime, would do Thursday to Wednesday, because then they were working more hours at the beginning of the week and we could adjust when we were quieter. So everybody has a different work week, so you want to make that clear so they know how to report that and when overtime would kick in. Now overtime applies to 40 hours in a work week. You determine the work week, and anything over 40 you pay time and a half on. And I jumped ahead a little bit. Also about meal and rest breaks. So you know there's no law that requires you to give meal periods or rest breaks. Now, unless they're under 16. There are certain whole different set of laws for those that are under 16. But you don't have to give that. But if you do say, hey, you know, we want our employees to take a break, and we want them to have their lunch period, whether that be an hour or 30 minutes or whatever you deem appropriately. But bear in mind, if an employee, this is where I ran into hospitality. Many times my staff, you know, we would fix lunch for our staff because we were kind of remote, and they didn't have time 30 minutes to get back. And so many times they'd be sitting in a lunchroom and we'd need to pull them off. Anytime that a person doesn't get a full 20 minutes or more, they get paid for that. So bear that in mind as well. And if you do automatic deductions, make sure that employee, when they're reviewing their time, whatever your pay period is, that if you're adjusting it, that they're initialing it. Because I've also had Department of Labor come on me and review those, and ding, 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 and those add up and that price. So if you do an automatic deduction for your meal periods, make sure the employees are signing off on those time cards and acknowledging they took that time.
Question.
Yes, ma'am.
So if the workday is scheduled for a 9-hour workday because it includes a 1 hour break, an employee would have the authority to say, I don't want that 1 hour, I'd rather have work my straight 8.
So bear in mind, you as an employee, that is a disciplinary action, is that, we want you to take that break, We feel it's important to do a break in the day. And that's also the importance of why supervisors need to review timesheets as well. Because if you're just, I wanna work my 9 hours, maybe you're not really working 9 hours, you are taking a little break. That's the supervisor's responsibility to ensure that their timing. There's always gonna be exceptions and occasions when that needs to happen, but you need to encourage those people, no, we want you to take that break. We feel it's important to refresh, to come back into the workplace and be ready to go again.
Because we get that a lot, and that call comes to me, because we have staff that may be on duty for 16 hours at a time.
Right.
And if they're on duty with a client that they're solely responsible for, we don't have another staff member come to that site to relieve them for 15 minutes and an hour. So they will often say, well, you guys are not giving me my breaks. So to know that that's not the law, that's really good. I'm gonna have to have that in black and white.
Right.
Yeah.
It depends too on the state, right?
Right, so I
Right,
would look.
state law could be different, but Virginia right now,
Right.
on that particular issue, falls along with federal.
And for a 16-hour shift, that may change something as well, so definitely,
Yeah, it's always good to double check.
yeah. But we've had cases where, and most of you probably do too, where somebody's working through their lunch, and so at the end of the day, you've got 43 hours.
Yeah.
3 are overtime, and your manager or your finance manager is saying, no overtime is allowed. And so that manager then has to be responsible to say, look, we are not approved for overtime, so I need you to work I need you to take your lunch break. Or you can say, then let's just work this out, and you can leave at 4:30 instead of 5. But at the end of the day, if they continue to work through their lunch and have overtime, that is a disciplinary action. And it's really on your managers to manage that.
So time record, so I alluded to this when we talked about meal break. It is really important to have your employees review their time and initial any changes that have been made, and to sign that they made those changes. Because Department of Labor, if they come and see that those haven't been acknowledged, you'll get dinged for that. And, they're going to take the employee's version of what occurred on that versus the employer's. So it is important to review and have time cards reviewed regularly.
So I worked at UVA for 10 years, and we would swipe our badge for our time. There was something in the handbook that said the quarter hour, in order to be paid for the quarter hour, it had to be 9:16 instead of 9:15. Any 15 or before, you weren't paid for that quarter hour. And I used to make a stink about that, because I would say, well, that could add up. I'm giving you a free 15 minutes every day, or, that time adds up by the end of the week. So is that, when it comes to time records, because I could easily see my staff having to do a duty for a client and not getting off at the exact hour.
Right.
What are the guidelines on pay for time, anything over 1 minute past your regular scheduled time?
So that's over a minute would be, I don't know that many payroll systems calculate based down that granular.
No.
But I think you should probably be reviewing, like, if someone works, is it 15 minutes? I mean, in my world, I think anywhere I've ever worked, we kind of consider the 15-minute mark. Now, if it's 10 minutes every day, again, that's going to pick up and be calculated if you have an automated payroll system.
So if for the time record, if the staff member, most of our staff members are doing a written record. and then I put in the time. But if I put in the time, put 5:10, or if I see 5:10, then I'm putting 5 o'clock. So you're saying it's, an understood log for the 15 minutes?
I would say, especially if it's very infrequent, but if you notice that that's the case every day, then I think that's a conversation and a review you're gonna have to make sure you are following like the Fair Pay Act.
I think the DOL has some information about rounding of time, and specifically if it's over and above 7 minutes, you have to be really, really careful. FLSA really frowns on the rounding down of time.
Right.
So I would definitely check out the
Right.
regulator's website.
Yeah,
Okay.
that's great. Thank you.
Yeah, and we've had that with a previous employer T and I worked at, where we had to put in the handbook, like from this time to this time, which was the 7 to 8 minutes. If that determined whether it kicked you back to quarter till 8, or whether it pushed you to 8. So you just have to have that communication with them. And again, if that's in your handbook and that's what you're saying, and they are not meeting those expectations and clocking in and out the way you want them to, and it's causing overtime, it's disciplinary.
So overtime, again, overtime is any time over 40 hours in a work week. And that's typically paid at time and a half. Now, there are different formulas for overtime, and, different organizations, based on what you do, may have a different calculation. So again, this is an important piece to go to the Department of Labor, look at specific overtime laws. We have one benefit is Virginia had changed their overtime laws, and what was that, 2020? 21, and just this past, 22. So in January, it changed back, thank goodness, because that was difficult. So just bear in mind, you need to look at both the federal and state, and Virginia state for the longest time mirrored right along with federal, and it was kind of easy to maneuver. But I think I would say the past 5 years, the laws are slowly becoming more employee friendly, and so that is making a change. So that would be one area I would encourage you to stay on top of, is state law and what is changing in the various things. Deductions from pay. So you can't make any deductions from a pay without the approval of the employee, unless it's the federally mandated, like your taxes,
Liens,
garnishments that come in and that type of thing. But, if you broke something and you do an automatic deduction, or they didn't turn in their uniform when they left, none of that can happen unless they've given you pre-authorization to make that deduction in the pay. So I would just advise, anytime you wanna make a deduction out of pay, except for those few that all of us have to live with, I would get their approval. That's health insurance. If that is any kind of deduction that you do for benefits, make sure you have them fill out an enrollment form or some sort of signature or acknowledgement that they've allowed this deduction to happen.
How about, withholding or like turning in keys, parking passes, those kinds of things?
you cannot hold their
You can't
final
hold
pay.
the final pay.
Right. Unless
There's something else
in writing that says they know that that's going to happen. And I would, when they're leaving, is do an exit interview. Remind them, okay, you need to turn in X, Y, and Z. Remember in the handbook, we talk about this. Okay, I'm gonna have you sign that we had an exit interview, and these are the topics we've talked about. I'd rather have it twice than not at all. And especially if they've been long-term, they've probably long forgotten what was in the handbook. So to remind them how it works when an employee leaves.
Do you have to spell out like the cost of the uniform or anything like that?
I think it's good to give them a summary about what's going to be deducted in total, and it would be good to give them an estimate of what that cost is, so they can make to know what to expect out of their pay.
Is that something you can add to your handbook? You know how you have some places
Sign it.
sign it? Yeah. Could you do that?
You could, as long as you have a signature on it, and just, go ahead and start thinking about, well, what are the things that we would normally want to deduct, or get payment back for. So I know with IT equipment, the general language is, the depreciated value at the time, there's this But, National SHRM and, the Virginia websites, the state websites have good templates. And so again, I would just encourage you, if you were sitting in this situation where, you're not direct, and even for HR directors, like I utilize those templates and those resources every day. Again, we would not retain all of this, I will never retain all of this information, nor do I want to, so I always pause and go do some research.
So let me get to her question, I'll be right back. Did you had a further question, I saw you raise your hand.
Yeah, we have a form that we have the employees sign for their uniform and any keys issued. And we put on how many shirts or how many pair of pants and what keys they're given. And we get them to initial it, and then the back page, it has a little blurb saying, I tell us, this is letting you know when you do leave, for whatever reason, all this, keys and shirts and must be returned.
Right.
Or,
But
you know,
it's good when they're leaving, make sure you reiterate
yes.
that.
And I think it has a little blurb in it saying about, the last check might be held until those items are returned, and they sign, off on it and date it.
When,
If an employee leaves, if they have already, signed up for insurance benefits, and they leave like middle of the month, we carry their insurance to the end of the month. Can we withhold the total price to
again,
carry to
part
the
of that
end of the month?
exit interview is talking about, like, you're leaving in the middle of the month, you're covered through the end, here's what's gonna happen. Now, you'll see a deduction for that, just however you do your deduction
to be
structured.
Okay.
I would just remind them
Okay.
of that.
Okay, yes ma'am.
Don't you have to at least pay somebody minimum wage, like say they worked X number of hours on their last check and you need to deduct $100 for the uniform?
And they don't, that doesn't come out to,
Yeah, and if it comes out below minimum wage, isn't that?
that's a good question.
Yeah, I would think that you would be covered if it's something signed, but again, that's something I would stop and go research.
Okay.
But that's a good question. Good question. So access to personnel files, certainly an employee has right to see their files, but they need to give you notice. So it's a 24-hour turnaround time. So basically, I always like to, if an employee asks, I like to review what's in that file, just so that I know what to expect. And what I do is ask them to come to the office, sit, and do it right there with, now I don't have to oversee them doing it. Now, I've had employees ask for copies, and then I was like, I have to think that through. Again, you would ask for more notice, I would review what's in the file so that you know. And then, those that ask for the file, sometimes you might know there might be more going on to that story.
Right.
That might be a sign to, let's just talk this through with the attorney, see what they say. Here's what's in the file.
And there is a federal or state law, it may be state law that minimizes what you do have to give them, and it's 4
Right.
or 5 items.
So,
And people are not very happy about that, especially, because typically when they're asking, there is a reason.
Yeah.
Exactly.
Yeah.
And they're not very happy when you say, well, I will give you, I can't remember what the 4 items are, but they're very basic, that would not really have any information that would put the company at risk or speak to employment actions during the time they were there. And typically they're not very happy with that, and again, it's because they're asking for a reason. So it does give the employer some protection there.
So, employment of relatives and domestic partners, that's, I think, up to an organization to make that determination.
Yeah.
Just my experience, that's touchy. Yes. And, so really, I would talk to your leadership team before and talk that through, because circumstances, you might have issues with one, but then you might have a really key employee leave on top of all of that. So just think that through. Okay. How do you move that?
This way. Oh, yeah, I don't think we can move the last.
Oh, okay.
Whatever that one was.
Okay. Workplace safety is an important piece. OSHA does require you to have a policy in place for workplace safety. And so depending on your organization, there might be even more criteria for OSHA to follow through on that. So, drug-free, and how are we doing in time?
We've got about 10 minutes.
Okay.
I think this is right.
The drug-free and alcohol-free workplace, even though, there's a minimal amount of marijuana usage that's legal, you as employers, it was on the news this morning, you as an employer can say, no, it won't be allowed or permitted. You need them to be fully aware of what's occurring. Smoke-free workplace, I think many of us now have, I don't know any place that does that anymore. Workplace violence is another important piece for the OSHA piece, and what to do if they feel like it's a scary work environment, and who to report to, and what signs that they might have, bearing in mind they're not experts, but they know who they work for, and if something's occurring. That's an important piece, is your health insurance may already have built-in an employee assistance program, and you can do a mandatory referral, and get them the help or encouragement that they might need.
And SHRM just came out recently, I believe, in September, with an article where active shooter training is certainly not a requirement, but SHRM is now getting information in and seeing that there have been lawsuits that are coming up against companies where there has been violence in the workplace, and the employer didn't provide active shooters. There's not been a case yet where the employee has won against an employer in the absence of active shooter, but SHRM is definitely bringing it to the table to say, even though it's not required, employers may want to put that into place. And I'll just say, it's good to have and to practice, even though that's not a requirement. We just did it in our office in Charlottesville today, so it's a very good training to have, to give your employees.
So, I'll go to emergency closing, just informing your employees what happens when it snows. Are we open, closed, where to go for that information? How does the pay work? If we decide as an organization to close early or open late, what happens with their pay? Or if they decide that they don't wanna come, what do they have to use? Do they have to use any earned leave on top of that? So that's where emergency closing. Also, visitors to the work site, and what's your stance on that, of having people who are not employed? Because, once somebody walks in, if I work in a warehouse environment, if they become ill or fall, that's a liability on us. So you want to think that through about visitors in the workplace. And then workplace guidance, what's your attendance policy, performance reviews, the expectations. What if they wanted to have a second job and work somewhere else? What's the stance on that? What's your dress code? And bear in mind, laws are constantly changing along these aspects as well. And state law has had even about your hair. I can remember working in hospitality, we said the natural color. And I had a Hispanic gentleman come with these bright blonde hair. That was a tough one, because blonde hair is natural. Maybe not for him, but.
Yeah. At a previous employer, we did have a manager's challenge who come to me and say, I really want this employee to not have the hairstyle that they had, and it had some color in it. And I said, so we want to just terminate everybody that has color in their hair? Yes. And I said, well, then I guess I'll get up to leave, because I have a few highlights in my hair, and the majority of us would have to leave. And so, if it's not a business necessity, or if it's not a safety issue, and for grooming, for males, especially black males, when you say no beards, like there is a medical condition where if they shave their beard, they get something that happens to their skin. Again, if it's not a safety issue, be thoughtful in what you are saying about dress and grooming, so that you're being inclusive.
Cell phone safety and driving, it's just, you think this is important, but if they're driving on your behalf and something were to occur, the company is liable in that situation as well. So you want to emphasize that. Your social media and aspects and what's expected there. Bulletin boards and posting. you know, solicitation, I can think of Girl Scout cookies, you know, how many of us have employees who, oh, my daughter is selling Girl Scout cookies. Well, that opens the door for the labor union to come in and say, well, you know, you wanna join our union? So just think that through, is that it does open the gamut. If you allow one, you've gotta allow all the pluses and the minuses that come along with that as well. About your computers, your internet, email, and other sources, you know, what should they be accessing? What happens if they cross that line in disciplinary? And then the disciplinary procedure as well, you know, are you a 3-strike, you're out kind of thing? Are you, here's the things that we hold dear, that it's really key to also emphasize, you know, it's up to termination, because every situation can be a little bit different in the circumstances, and you have to think that through. Though if you're gonna treat one employee like this, how is it gonna apply to somebody, either your favorite person or the least performing person in that? And you've gotta follow the same guidelines and procedures. Time off, if you wanna talk about what holidays you cover, your vacation or your sick leave, or a combination of PTO. Family medical leave would go in this area, your military leave policy, bereavement leave, what happens and who is eligible, right? Is that for immediate family? What does immediate family mean? And I worked at an organization where the debate was, well, you know, not everybody is raised by a parent. You might be a grandparent, it might be a sibling, it could be kind of outside the scope, and so you might say, who raised you? And that, what happens when you're called up for jury duty? I just went through that with Green, and for 3 months I had to keep calling. You know, I'm thinking, or I can remember in hospitality, you know, and you were out 15 or more days, and that's when the O.J. Simpson trial. You know, what if an employee is stuck in one of those trials? At least letting them know, okay, we'll pay up to 15 days, it's 15 days of jury leave, so that they can let whatever court system. You know, I could risk, you know, losing my job. And time off for voting, how that works. Yes,
I'm
ma'am.
sorry, do you have to pay them for jury duty if they're gone?
I don't think
You don't have to.
Right?
You don't
Okay.
have to,
Alright.
but you wanna make that clear.
Right,
In that aspect of
Yeah.
it. And then you wanna talk about, you know, do you give time off for voting and encouraging that? We used to, one organization, an hour grace time, you know, to allow them an opportunity to go vote, either in the morning or in the afternoon. But we encouraged them, they need to tell their supervisor ahead of time, so that
There's
they
a state
can.
law regarding
Is there?
yeah.
Okay,
So we'll
good,
check
thank
that.
you. That's a good point, so
Oh.
check that. Are we done? No, I think I went
there's
the wrong
one
thing.
more.
It's okay. I hit the wrong button.
So we're hitting time, so one of the last things to really remember is the handbook acknowledgement and receipt. Have them sign that they read it and understand it. And if they if they have any questions or any issues understanding a certain policy, make sure the language is in there that it's also their responsibility to ask for clarification. And get that signed and keep it in your file. So quickly, starting July 1st, 2021, Virginia employers with more than 5 employees must include in their employee handbook information on reasonable accommodations for persons with disabilities. So again, this is where it might differ from federal law. You are supposed to enter into that interactive reasonable accommodation process, and so now it actually has to be in your handbook. So we will not likely have time to do I-9. However, we do have a checklist for I-9 and an article about an I-9 audit. We are happy to send some of that stuff out. If I got it directly from SHRM, I'll have to get my approval first to use it, the permissions to reuse. But we have some stuff from lots of other sites too. Again, DOL.gov, EEOC.gov, USCIS.gov, retirepathvirginia.com. And again, I would encourage you to come join Charlottesville SHRM. It's $45 for the year. You can pay as you go for meetings, or you could join for a membership, annual membership, and go ahead and pay in advance for the whole year for meetings. It doesn't include the conference. And again, National SHRM, great resources. We're never gonna have all the information and things are changing. I'm sure while we've been sitting here, something has changed or it has been proposed and put to, you know, the legislature that something wants to change. And so we're never gonna have all the information. That's okay. Be pause and be thoughtful and check your resources. And never hesitate to pay for that 1 hour consultation with an employment attorney. It will save you lots of money and a lot of heartache. Okay, so that's really all we have today. We'll work with Anne Marie to get some materials out, especially on the I-9. We look forward to.
Before everybody gets up, do you mind if I grab a picture? I took a picture earlier, but everybody's got their meeting face on. Sharon and Mark.
Okay.
What are we
You want
going
me
to
to
say
sit?
lights in the background? I got you. All right. Okay, here we go. Thank you.
Yeah.
Sometimes I make everybody squish up along the wall, but it's
Right.
Thank you for coming.
All right,
We love
thank
to
you
have
all.
here.
Thank you. It was very informative.
Oh,
Thank you.
good.
Yes.